The National Association for Stock Car Auto Racing, NASCAR, and its CEO, Jim France, have both filed motions to dismiss the antitrust lawsuit launched against them earlier this fall by 23XI Racing and Front Row Motorsports, resulting in a huge upset in the case and a potential loss for the teams. In the request, which was filed on Monday, December 2nd, the sanctioning body lists various reasons why they think the complaint has no basis, appealing with the court to dismiss the matter immediately. According to NASCAR, the majority of 23XI Racing and Front Row Motorsports allegations are precluded by the statute of limitations and latches because they occurred more than 4 years ago. This covers the acquisitions of ARCA and ISC, the implementation of next-gen car standards, NASCAR's exclusivity agreements with racetracks, and the 2016 charter clauses. Plaintiffs lack antitrust standing to sustain their challenges to the 2025 charter's release of claims and non-compete provisions, which are their only claims that arguably fall within the statute of limitations, because plaintiffs did not sign the charters and their failure to secure preferred contractual terms is not antitrust injury. The sanctioning body refers to a specific section of the legislation in which the teams propose a market definition that is post-investment rather than pre-investment. Under established law, a plaintiff cannot establish a relevant market by claiming to be trapped in a market, knowing that doing so would result in sunk costs and other dangers. Finally, NASCAR claims that 23XI Racing and Front Row Motorsports failed to allege exclusionary behavior since the sanctioning body did not refuse to work with the plaintiffs, and they have not pled evidence demonstrating that any of the challenged charter clauses lowers competition. NASCAR's memorandum of law in support of the request to dismiss states, for example, plaintiffs admit the charters are worth millions of dollars that NASCAR boosted the income available to teams during the last round of talks. This behavior is the polar opposite of what one would expect from a monopsonist. If NASCAR genuinely had market power, it would reduce its demand for plaintiffs' services and the amount by which it rewards them. In a second document, Jim France, NASCAR's CEO, who is also named in the action, files a petition to dismiss, alleging that the plaintiffs, 23XI Racing and Front Row Motorsports, are inappropriately dragging France into a legal dispute. Plaintiffs improperly seek to drag NASCAR's CEO, Mr. Jim France, into a legal battle motivated by plaintiffs' inability to secure all their preferred contractual terms from NASCAR during the negotiations over the 2025 charter, the petition continues. Plaintiffs' antitrust claims against Mr. France are just as baseless as their claims against NASCAR and should be dismissed for the same reason that the claims against NASCAR should be dismissed. They also fail because plaintiffs have not provided any factual allegations showing Mr. France actively and knowingly engaged in the alleged anti-competitive scheme. The absence of such allegations is fatal, and the claims against him should accordingly be dismissed. At this point, 23XI Racing and Front Row Motorsports have filed a second preliminary injunction motion, hoping that the court would find that they can race under the 2025 charter agreement for the duration of the dispute. NASCAR, unsurprisingly, is opposed. 23XI and FRM will have until December 16th to reply to NASCAR's move for dismissal. Thus, the bitter lawsuit dispute pitting Michael Jordan's 23XI Racing and Front Row Motorsports against NASCAR has escalated into heated court papers about holiday scheduling. As reported, 23XI Racing and Front Row Motorsports have revived their demand for a preliminary injunction. If granted, the injunction would allow the two teams to compete as if they had a charter agreement, despite the fact that they had not signed one. It would also ensure that the two teams do not forfeit antitrust claims, even if charter teams contractually waive possible claims as a condition of their charter. U.S. District Judge Frank D. Whitney dismissed the first application for injunction, citing 23XI Racing and Front Row Motorsports' failure to identify what particular injury or harms would arise in the absence of an injunction. The second request seeks to remedy this shortcoming by arguing that the two teams had signed a time-sensitive deal to purchase a charter from Stewart-Haas Racing that, without an order, would require them to abandon their antitrust allegations. However, NASCAR is also trying to overthrow this request. In connection with the updated request, 23XI Racing and Front Row Motorsports insisted, through attorney Jeffrey Kessler, that Whitney approve an accelerated briefing and hearing timetable. The sides contended that the time-sensitive nature of their motion, combined with the Thanksgiving break, justifies an expedited schedule. 23XI Racing and Front Row Motorsport went on to say that their business partners have requested conversations occur as soon as this week. The two teams also noted that December 17th, 18 and 20 are all key dates to meet certain contractual deadlines, though the teams declined to specify what those deadlines concern. The plaintiffs suggested that NASCAR answer to their updated motion by December 6th, then the plaintiffs react to NASCAR's response by December 10th, then Whitney have a hearing on December 12th or 13th. However, NASCAR, through attorney Tricia Wilson-McGee, contended that the plaintiffs failed to demonstrate good reason to hasten the usual timeline and asked Whitney to deny their motion. According to NASCAR, 2311 Racing and Front Row Motorsports tactically delayed filing their new motion for a preliminary injunction for over a week and intentionally dropped it on NASCAR and the court in a late-night filing on the eve of the Thanksgiving holiday. NASCAR further noted that the plaintiffs announced on social media their intention to file a revised motion, but then waited many hours to do so in court. As for 2311 Racing and Front Row Motorsports claiming the need to meet certain contractual deadlines, NASCAR contends that such a general assertion does not warrant an abbreviated schedule, especially since, as NASCAR put it, plaintiffs decided to wait to bring this renewed motion for over a week after becoming aware of their claimed changed circumstances. NASCAR also stated that its attorneys are already working diligently to fulfill other deadlines in the action, including as responding to the plaintiff's complaint and filing a request to dismiss by December 2nd, which they did yesterday. Whitney considered the opposing arguments before declining to approve the plaintiff's proposed schedule in a judgment issued Wednesday. Whitney, using the court's inherent authority to manage its docket, chose December 9th instead of December 6th as the deadline for NASCAR to react, and December 12th instead of December 10th as the deadline for 2311 Racing and Front Row Motorsports to answer to NASCAR. The court declined to establish a hearing date on the fresh motion, stating that one will be issued in a future order. If 2311 Racing and Front Row Motorsports are unable to postpone their contractual deadlines of December 17th, 18, and 20, Whitney's scheduling of a hearing and ruling on December the 17th of May be critical. Whitney, like other federal district judges, preside over many cases concurrently. This is vital to consider when assessing his ability to accommodate the schedule needs of a party, even a multi-billion-dollar corporation such as Michael Jordan or NASCAR. A brief check at Whitney's calendar from December 9th to December 17th reveals that he has scheduled hearings for other matters, including sentencing hearings for defendants in criminal charges including carjacking, theft of government monies, and other offenses. While professional sports litigation attracts media attention and sometimes involves large monetary stakes, courts typically consider them like any other case and do not give them precedence because of their notoriety. The saga continues as first and foremost, despite not having signed up to the charter, 2311 Racing and FRM requested an injunction to continue as de facto charter teams for the duration of the dispute. However, a judge refused this, claiming that 2311 and FRM did not meet the high standard required for such an order. This was first appealed, but the motion was eventually abandoned after NASCAR eliminated an anti-competitiveness restriction from its agreements, allowing 2311 and FRM to run as open teams next year. That appeared to be the end of the problem, as 2311 and FRM issued a joint statement hailing the result. However, things appear to have taken a dramatic turn, with the teams issuing a joint statement announcing another petition to the courts. In a statement, the team's attorney Jeffrey Kessler stated, "Consistent with Judge Whitney's earlier ruling, 2311 and Front Row Motorsports are submitting a second preliminary injunction to the court with new evidence. My clients are also seeking this relief to strike down the release language that NASCAR removed from its open agreements but still maintains in its charter agreements as part of its monopolistic control. I'm confident the court will act to protect my clients from NASCAR's anti-competitive conduct. It will be fascinating to see how this latest submission plays out as the struggle between 2311, FRM, and NASCAR continues. The idea of both parties leaving the negotiation table happy are getting smaller and smaller. What do you think? Will any of the parties come out victorious? Or are they all set up for failure here? Let me know your thoughts in the comments down below.